okay? We love them.
That's right though.
For us guys, Zabo is like the godfather, okay? We love him. He's been around for a long time now.
That's right though.
For us guys, Zabo is like the godfather, okay? We love him. He's been around for a long time now.
That's right though.
Say, that's crazy, bro.
What's your name? What's your name? Zabo? Ooh, that's different.
For us guys, Zabo is like the godfather, okay? We love him. He's been around for a long time now.
Ooh, that's different.
For us guys, J-Lo is like the godfather, okay? We love him. He's been around for a long time now.
I would say when you get in the
For us guys, J-Lo is like the godfather, okay? We love him. He's been around for a long time now. godfather, okay? We love him. He's been around for a long time now. For us guys, Zabo is like the godfather, okay? We love him. He's been around for a long time now.
Good Friday. This is Big Jeff. It's nothing but the truth.
And I am his co-host. I am Shanita Ben, Absolute Justice Now on Instagram.
All right, today we want to take y'all back and we're going to refresh everyone on the case of the trial date of when the illegal search. Like I said, we're going to bring everybody up to par. So we'll be taking a few days to bring everyone up to par on, giving you the insights of what has taken place so everybody can be free-spirited and free-minded to catch up with the case for those who haven't had a chance to really just follow the case attentively every day. Now, what you going to talk about today?
I'm going to talk about just exactly what he just said, the things that they don't want you to know, the secret little details that if you're not there, you may miss. So we just want to make you guys aware and keep the public aware of the happenings, what's going on as it happens in real time, real people.
All right, so we're taking you back to the day that the case was thrown away, as far as the judge
March 19th.
took the case off of the calendar on March 19th, 2022.
Yeah.
And the reason being was because he asked the state attorneys that was first on the case. The question was, how did they receive all of the evidence and taking it out of property, which where it was stored? And the question was, how did they get the evidence out of property or anything that they could use as evidence out of property when the property was turned back over to Jeffrey Williams, which is Jeffrey Williams Sr. So we're going to talk about that today and upgrade you on when the YSL RICO case was actually thrown out. As far as we were concerned, it was thrown out of court because the state was granted permission not to be able to use it. They was actually told that they couldn't use any evidence from 2015.
But of course, they still insisted and tried to get it in any way possible that they could, correct?
Yeah. So we're going to play a little bit of it so you all can see it and you can hear it for yourself. The question was asked, why were they able to obtain this information, and I wasn't able to get my property back by no circumstance, and I attempted to get it back 3 times because it was awarded back to me. So here we go.
Mr. Bailey, the district attorney, on page...
Can I interrupt you a second?
Yeah, of course.
IT is about to create a new secure Zoom link, but it's only for the attorneys. You're not to share the link. You understand me? Good? All right, thanks.
This is
okay.
March 19th, 2022.
I'm sorry. Continue.
That's okay.
I apologize.
On page 3, 34, Your Honor, of Court's Exhibit 2, line 3, this is Mr. Bailey, the district attorney at that time, or senior assistant district attorney. On page 3 of the motion, it states, Mr. Williams was arrested on a DeKalb County warrant. However, law enforcement officers unlawfully entered and searched Mr. Williams' home, even though they were supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home in an effort to serve this alleged arrest warrant, as there was no lawful reason to force entering Mr. Williams' home. Then there are 2 parts here, and that's the long and short of it. Did they, meaning police, have the right to effect the arrest warrant, and what did they see once they got inside that would rise to probable cause. Then skipping, Your Honor, to line 21, same page 34, this is Mr. Bailey again. Normally, officers can't just walk into folks' homes. That is well established, but there is a carve-out for affecting. Officers have reasonable belief the individuals inside. So it is not this way the state is saying that it's only somehow marijuana. I challenge the entry into Mr. Williams' home. When law enforcement went into the home, they allegedly found marijuana, guns, other contraband, and that's when eventually the seizure of all of Mr. Williams' electronic devices that I've challenged, that should have been returned, I've challenged, cannot be used in this case. On page 35, the district attorney said, it's at the end of line 1, Your Honor, or it's the middle of line 1, an arrest warrant found on probable cause implicitly carries with it the limited authority to enter a dwelling in which a suspect lives when there is reason to believe he is within. The state is saying the entry into Mr. Williams' home was unlawful. He has his constitutional right to violate. He's a victim. The court should say respectfully, no way, this would litigate it. On page 36, the district attorney continues. It's on line 10, Your Honor, and the parties. Now, were the facts that they knocked and he came to the door, and they, meaning the police, Your Honor, detained him, meaning Mr. Williams, then Mr. Steele would be completely correct, and they could not enter the home. They affected the arrest warrant. Then skipping to line 19, Your Honor, page 36. So they have all clear lawful authority, talking about the police, to go in to effect the arrest warrant. And then we get to the second point. And it is in the same Wall case. Wall is W-A-L-L. It states on the last page, once inside the apartment, the law enforcement officers had the authority to seize marijuana that was in plain view. I challenge that law enforcement had no right to go into Mr. Williams' abode. And then the prosecutor on page 36, line 25, concludes, that is exactly what we have in this case. Once law enforcement is inside, they see marijuana on the coffee table in the master bedroom suite, and additionally marijuana on the nightstand in the master bedroom, and Detective Gaither further testified there were guns located in the living room. So that is, I challenged, I had a hearing, we won the hearing, it was a final judgment, not appealed. I am not respectfully required to do it again so the state can bring their A game, lose, and then bring their A plus game and try to win before this court. That's not the way, I don't get to do that, ever.
But it wasn't appealed. I mean, there wasn't, Judge Newkirk's ruling could have been appealed by the state, or could have been appealed by you within 30 days of the entry of the order.
Why would I appeal it?
Well, no, you wouldn't appeal it.
And the state doesn't appeal. What does that mean? It becomes final. The court cannot amend that.
Always tried to give the state some type of leeway and some type of idea as to how to argue the case.
Mm-hmm. Giving them little hints on how they should appeal or how they should move or how they should, proceed. Whereas if it's the defense, he's always on the offense. He's always trying to deter them from pretty much winning their argument.
Definitely. Now, we're going to watch some more.
In that order, you'd be amending the finding on between the same parties on the same exact issue. They don't get the second, in the case law it says second bite at the apple. Then, Your Honor, on page 38, line 14, this is the district attorney again. So it's just not an issue that makes any distinction or any difference. It's clear here that it's clear here they, meaning the police, had authority to go in to effect without the arrest warrant because Mr. Williams wasn't outside the house and he didn't come to the door. Once inside, law enforcement saw illegal contraband drugs. That is probable cause to get a search warrant all day long in any jurisdiction in the state. Your Honor, the police had no right to enter. That ruling was made. I then say on page 39 of the same Court's Exhibit 2, line 1, I get to speak. The court gave me the opportunity to speak. I said, thank you, Your Honor. Your Honor, we are traveling under, I'm assuming the court has it. If not, we'll get you a copy. There was a supplement to motion to suppress, and this is what I'm stressing, sir, the Honorable Judge Glanville, any and all evidence located
Let him know we lost the value.
Hello and welcome to Venom Motorsports Product Walk Around. Today we got the 125cc Venom Willys Mini Jeep. This is a 125cc 3-speed semi-auto.
lawful, and his arrest would be unlawful. And then the fruits of the unlawful arrest may not be introduced into evidence. An arrest warrant was never part of the record below. An arrest warrant not put in evidence, while the witness testified or at any other time. The participants in the suppression hearing refer obscurely to the warrant, the warrant in the case. But there is no document to show that there is an arrest warrant. No judicial officer testified that he or she issued an arrest warrant. If the arrest warrant in existence, no reason whatsoever appears for the state's refusal to put it into evidence in the face of a demand. And I continued, I didn't write, I spoke, page 41, line 1. Mr. Williams demanded in paragraph 7 of the supplemental motion and challenge that there is an arrest warrant. If there's no arrest warrant introduced in the hearing, then we go down the road in kind of an outline. So if there's no arrest warrant before this honorable court, which there is not, then law enforcement officers, according to Sergeant Gaither, 30 or 35 law enforcement officers surrounding his home, Sergeant Gaither, which is Gaither, did not go into the home. However, law enforcement officers entered this home. This honorable court has no evidence that they entered lawfully. Supposedly, he goes into Mr. Williams' bedroom. Now Mr. Williams is outside. So my first issue is the initial entry without the arrest warrants vitiates everything coming afterwards. That was my argument. On page 42, line 12, I argued to the Honorable Judge Newkirk. So my issue, I said right, period. So my issue before this honorable court is the first entry, obviously without the arrest warrant at this hearing, is unlawful. Then the second can't be saved by the second entry either, because that would be without lawful blessing, same thing as unlawful search, the second one we're talking about. Then the search warrant issue, this would be my third issue. So first one, no arrest warrant. I am challenging, it is clear to everybody, including when you read the state's motion for reconsideration that I've already entered, Your Honor, at the last hearing, everyone knew I was arguing that the entry into Mr. Williams' home was unlawful, and therefore everything in that home could not be taken.
Okay, now what we have in here is the first arrest, the first warrant that they went and I guess made up themselves was because they was coming to serve a warrant for a terroristic threat. Okay, and on coming to serve us, they came and they saw something that looked like marijuana on the table because they was able to look in the door. And that's when they went and obtained the second warrant. So that's what he's speaking on when he's saying it can't make the second warrant, go because it wasn't done in the beginning. All right, so we're gonna continually listen. These are the shenanigans that's been displayed throughout this entire trial. So, we really gonna update everyone on what's really going on and what has taken place that was totally unlawful to any of these guys that they put in this RICO. And like I say, and I'll say it again, because this RICO was bogus from the beginning. All right, we're gonna click you back in.
Taken, should have been suppressed and returned to Mr. Williams. And the state's reliance on Alford, State versus Alford, the state's reliance on this narrow window that only the Honorable Judge Newkirk suppressed marijuana is frivolous. On page 43, starting line 4, I continued. But then when the court goes through and looks at the search warrant itself, the only way we would have probable cause in the search warrant is if the court finds that law enforcement officers on the day that this happened actually had the lawful right to go in the house and to observe, because everything else in that search warrant does not produce probable cause to search Mr. Williams' home. Then it continues on page 45. On line 4, at the end, I say in the middle of the sentence, nothing is attached showing that this arrest warrant was valid from DeKalb County. On line 40, page 46, on line 5, the next issue, Your Honor, that is asserted is that law enforcement officers entered Mr. Williams' home on the day that we're talking about, and I challenged that in the supplemental motion with the fact that it was read to this honorable court by the district attorney, supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home because I'm challenging the arrest warrant was not valid if there is an arrest warrant. And the last issue in the affidavit for the search warrant discusses items that were located by law enforcement officers during the search on the day that you heard about, which I would say is a fruit of the poisonous tree. So I have 3 issues. 1, there is no at all arrest warrant presented to this court. So under Baez, which I have a copy for the court, how can I challenge the arrest warrant? How can the court say it's a lawful arrest of Mr. Williams at his home without being armed with a certified copy of the arrest warrant? Therefore, and I stress this, Your Honor, everything thereafter falls as fruit of the poisonous tree. On page 47 of the transcript in courts number 2, on line 9, I continued. So the only thing we're left with is the unlawful entries into Mr. Williams' home, and I would ask the court, based upon that, suppress the evidence, grant the motion to suppress. Mr. Bailey then speaks on page 47, line 14, and going to line 18. At the last word, he says, this motion to suppress the search of a home that the defense is alleging is illegal. Nobody's talking about only marijuana. Mr. Bailey continues on page 48, in line 10 in the middle. The only 2 questions, Your Honor, are, did they have reason to believe Mr. Williams would be there, and so they could go into the house and get him? That's it. And then secondly, once they're in the house, did they see something that would give them probable cause to obtain a search warrant? Those are the 2 issues, not whether the arrest warrant out of DeKalb County was valid and whether the case was eventually dismissed or anything like that. The court then, on page 49, on line 6, says to the state, in which case you would have produced a copy of the arrest warrant. And Mr. Bailey says, right, which would have been a subject, I'm sure, of the suppression motion at that point. And then the Honorable Judge Newkirk said, well, it sounds like Mr. Steele made the arrest warrant a subject of this motion, also in a supplemental motion which the court filed does not have. What does it, what?
The audio went out.
The prosecutor says, and that is the copy, the supplemental one. Again, he's not challenging the arrest in this case. He mentions something in there about the DeKalb arrest warrant. If he wants, there's no need to challenge the DeKalb arrest warrant now because the case was dismissed. But there is a forum for doing that, and that may be what they did in the case. Maybe they challenged the arrest warrant in that case. On page 51 of court's number 2. The district attorney states on line 6, that doesn't mean that because there's not a certified copy of that arrest warrant that has any bearing at all on whether the entry and subsequent search of this house was proper. Everyone's talking, Your Honor, about the entry. That would be the state's argument in the case. At line 11, the Honorable Judge Newkirk said, all right, tell me again about Baez. I'm not familiar with it. What is the site? Is it Supreme Court or Georgia Supreme Court? I say Court of Appeals. I give the court the site. And then on line 51?
51, okay.
Yes, sir.
All right. Yep.
And then on line, the court asked me for a summation on Baez again, and I said, okay. That's on line 22. So it's a motion to suppress like we're dealing with here. Law enforcement officers have obtained a search warrant after an arrest warrant. So it's the same sequence here. Going on to page 52, Your Honor. Law enforcement officers utilize the arrest warrant. They call it several things, bench warrant, arrest warrant. And just like Mr. Williams, it was challenged whether it was a valid arrest warrant. The motion to suppress hearing goes forward. The prosecution doesn't put forth the arrest warrant. The Court of Appeals says without the arrest warrant, it is not in the record. We are not finding there was an arrest warrant. It was challenged, and they suppress the evidence and find it is a fruit of, since there's no basis in the record to have an arrest warrant, everything thereafter is unlawful. That's exactly what I think happened here. That's why I used the case. Why did I make the supplemental motion to suppress all evidence located from Mr. Williams' home? Your Honor, I was challenging everything. It is clear. And I'll get to the Judge Newkirk's order because it's not a fair reading of the order to say only the marijuana. That's not true. I didn't write that order, by the way. On page 52, line 23, I say, and I don't want to play games with anybody. I put it in its own paragraph. I made it a supplemental because I realized there was a problem with the arrest warrant. So I made paragraph 7 standing alone, or standing on its own, and I wrote, moreover, law enforcement officers were not armed with a valid arrest warrant in DeKalb County at the time of entering Mr. Williams' home, and thus, and Your Honor, I'm stressing this, all evidence must be suppressed on page 53, lines 1 through 5. Then skipping to line 15, I again plead to the Honorable Judge Newkirk, the law should be followed in this case, and I say, but I guess it goes back to if the first arrest warrant is not before this honorable court, according to Baez, it was challenged, just like I challenged it on behalf of Mr. Williams, then how can this court sit here, the evidence that you heard, and say, well, there's a valid arrest warrant? We challenge that there's no valid arrest warrant, and then it's not saved later, in my opinion, the search, because I don't know how else law enforcement gets in the home. Because now you know, thank God there's not a shootout in the house where law enforcement had to go there. On page 54, line 5, Your Honor, I continue. So I don't know how law enforcement, without a valid arrest warrant here today, has any evidence to go before the court, and that is why I made an issue of the other items in the search warrant, like the confidential source, the alleged confidential source, the murder of Mr. Thomas, because all of that doesn't save the search warrant, so that's why I thought it was important. The court states, the Honorable Judge Newkirk, on page 55, its ruling. On line 18, the court says as follows: all right, Mr. Steele, I'm going to go with you on this. I think you are correct. I think the burden is on the state to show the initial arrest warrant was valid and initial entry into the house was valid. And he hasn't done that, meaning the prosecutor has not done that. It appears there's no testimony from any officer. Certainly, there's no need for her to go back in the house without a search warrant. It doesn't sound like she searched for anything, so that might have been harmless, excuse me. That might have been harmless error because the arresting officers discovered it and went out and told them. And this is what I'm stressing. Line 4, page 56, the Honorable Court's ruling. But I don't think we get to that hurdle because the lack of authority shown to the court that they had permission, meaning the police had permission to enter the house on the front side. So I will grant your motion, Mr. Steele, if you will prepare a proposed order. I never did the proposed order. I don't know why I wouldn't do that when I'm told. Maybe I did and the judge didn't like it. That's not my order. The bottom line I'm trying to tell this Honorable Court with as much earnest and power and professionalism as I can is I do not want to relitigate this after I gave a roadmap to the prosecution on how to litigate. If they need me to help them litigate a case, I'm not helping them. The issue here is we had the hearing. I challenged the initial entry into Mr. Williams' home. He is the victim of constitutional rights that have been violated, and the state doesn't get to go back and do it again. Then Judge Newkirk's order. If you look at his order carefully, Your Honor, he does not just suppress marijuana. The prosecution, and they're great people, but on page 33 is all they want you to do, Your Honor. They want you to be in your foxhole and just focus with tunnel vision and say when the judge said all he's challenging is the marijuana and act like, well, that's all there was. The judge found that the entry was unlawful. We don't get to do it again. And Mr. Williams then tried for a year and a year to get back his property. And what did the police do? They tell him, it's the evidence. We're not giving it to you. The statute says it. And now, today, the state wants to come in and say, well, we had another search warrant. I will talk about that search warrant in a moment. Let me just show you, if you don't mind, the order of the Honorable Judge Newkirk, which I forget the number.
It is D4.
And, Your Honor, in the...
That's the first one.
Thank you, sir. And it's entitled, it's filed, I know the hearing was on the 3rd of April, 2017.
Filed in on the 11th of April,
right.
2017.
So D4, order granting supplemental motion to suppress, and I'm stressing it, any and all evidence located from defendant. It's Mr. Williams' home. It says it's used defendant's home. After hearing testimony, a stipulation of testimony, an argument from the parties on Monday, April 3rd, 2017, this court hereby grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. There is nothing clearer in the world of what was suppressed. The prosecution is intellectually not being straight. Based on this ruling, meaning everything's gone, the evidence located in Mr. Williams' home that is subject to this accusation. That's all. The accusation was just a marijuana case. Specifically, just over an ounce of marijuana is hereby suppressed and cannot be used in evidence by the prosecution in the trial of defendant Williams. Do you know where the judge got that language from? I know I didn't do this order because I would always say the Honorable Court. This is just not the way I'd write an order. But you know where the court did get the language of what the state wants to rely on, specifically just over an ounce of marijuana, it's in my motion. I said suppress everything, specifically including the marijuana. It is not true what they are telling this honorable court, and that's not acceptable. Then you go to the search warrant. The state wants to rely on a search warrant from 2016. It was signed by the Honorable Judge Woodson. It is signed, and it's in your court's file. I believe it's defendant's number 10, I'm going to tell this honorable court. And it was signed on June 27, 2016.
I have the warrant for search and seizure as D10. You introduced that last time.
So, Your Honor, this is the same items that were taken from Mr. Williams' home in July of 2015. It's the same exact items that should have been returned. The state of Georgia has a search warrant. What they don't tell you, and I'm not saying they're hiding it, they just didn't tell you, is that they couldn't get into Mr. Williams' devices. They sent it to Cellbrite with the search warrant. And Cellbrite wrote back, and the GBI, we can't get in the devices. The search warrant then is never applied for again to tell any court, like this court, by the way, there was a hearing and all the evidence was suppressed. The state is using then in May of 2017, after Judge Newkirk suppressed the evidence in April of 2017. The state then sends Mr. Williams devices when they won't give it back to him. They won't restore it to Mr. Williams or his father, who had a power of attorney. They go to Cellbrite. And Cellbrite now has better.
Try to get this volume back in for y'all. We'll rewind it. Hopefully we can rewind it. Can we rewind a little bit?
Are we still live?
Yeah. Go ahead. You want to say something? Yeah, so this is a narrative of what took place and what's been done that was against all of their
Open the items. They don't get.
So we're going to continually listen.
We are having technical difficulties at the moment. However, we will be correcting that shortly. But it just goes to show that these are some of the tactics and some of the illegal things that have been done corruptly in this case. How can you go in someone's house and take their belongings illegally and hold on to them and not return them? Just all kinds of corrupt stuff from the beginning.
So once again, this is part of the bogusness of this indictment in this
Lines of this code section, Your Honor. Any search warrant not executed within 10 days from the time of issuance shall be void.
Talk, Mr. Steele, sorry.
Shall be void. Not continue until a new order is false
Mr. Steele,
order
go
is
ahead, sir.
created.
That's an intentional distraction right there.
Okay, go ahead, sir.
(17-5-25), the last sentence that the legislature taught us. Any search warrant not executed within 10 days from the time of issuance shall be void and shall be returned to the court of the judicial officer issuing the same as, quote, not executed. The state doesn't have a search warrant in 2017 in May. They steal Mr. Williams' property. They illegally enter his home. They steal his property. Then they keep it, the stolen property. They keep his stolen, the property they stole. And then they go to Cellbrite and they ask him in May of 2017, after everyone's on notice that the motion to suppress was granted, not even appeal. They didn't have the guts to appeal. And say break into the devices. I mean, what are we doing here? And they want to do it again. I respectfully ask the court to enforce the collateral estoppel, res judicata, law of the case. It should have been restored. The police should not have had that evidence. It should have been given back to Mr. Williams. He shouldn't even have had to ask for it. And I think that State versus Alford, I'm sure the court has read it. It is telling the court something that the case does not discuss. It is just not even arguable that that case matters to this. That they had additional reason to go into the home, into the car in Alford. They had the automobile exception. That is my argument when you asked me. I hope I answered your question, and I thank. I'll answer any other question, but I hope I answered your question.
You did, sir. You did. Ms. Rosenwald?
Your Honor, I know Mr. Steele has an interpretation of the language of the order.
I think that his interpretation is right. I'm just going to tell you that. I mean, I look at the way it's capped, it's styled and everything else, and it makes sense with what you're asking me to do is kind of just narrowly kind of look at the marijuana and not anything else has been seized. He challenged everything that was taken at that particular point in time, and it's clear in the transcript that he did in fact assert the fruit of the poisonous tree. I mean,
so, Your Honor, if I may, when I looked at this case first and I saw his motion, I was sort of thinking the same way as the court, and then I thought, I'm going to check the case law, and I'm going to check what the actual order says. And when I looked at the order, that's when I started thinking it might be something different. And whether or not we interpret it a certain way, the language itself, the plain language, and I know that the directive from the appellate courts has been to look at the plain language of statutes, to look at the plain language of orders. The language itself says, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana. If the court had intended to suppress the remainder of the items after just stating, so the court says, the court grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. He could have just said that, and that would have been a different ruling. But instead, the judge then said, based on this ruling, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana, is hereby suppressed. If the court wanted to make a ruling on the fruits of the poisonous tree, it could have, but it's clear from the transcript. And I'm not going to say Mr. Steele didn't argue about that during the hearing, but he didn't ask the court, hey, Judge Newkirk, can you please make a ruling on the fruit of the poisonous tree? There was no ruling on fruit of the poisonous tree. We're not talking about a second bite of the apple here. We're talking about him now challenging a search warrant that was not challenged before. And I think,
though, that's the thing about it. I mean, I think it's clear from the reading of the transcript and the exhibits 1 through 10 that were admitted when we were here on the 17th of November that he challenged everything: the arrest warrant, the search warrant, and he, in fact, he filed a supplemental motion to that extent. So Judge Newkirk granted the marijuana was only the subject matter of what you prosecuted him for at that point in time. You had other things that were
a poisonous tree, now and only now would Mr. Williams be able to demand his cell phones back. There has never been a ruling on the cell phones until this day, and I think that's really clear from the court's language in the transcript. Specifically in the transcript, the court says, and this is in the court's ruling, and Mr. Steele actually read it, it says we didn't get to that hurdle. So this is at page 55 through 56. The Judge Newkirk says it doesn't sound like she searched for anything. So that might have been harmless error because the arresting officers discovered it and went out and told them. But I don't think we get to that hurdle because of the lack of authority shown to the court that they had permission to enter the house on the front side. So I don't think we get to that hurdle. There is no ruling on fruit of the poisonous tree. There was no previous ruling on the cell phones. To the extent Mr. Steele wants to make an argument about the other search warrant in the other case, that other search warrant.
That's the end anyway.
If you're a man who makes at least 150 grand a year and you're still embarrassed,
He stopped it. That was the end.
Okay. Hello? Yeah. Now, as we can see, as everyone can see that, it was, we have been going through a lot of conflict throughout this entire case, so that's why we chose to be different and bring everybody up to par with the things that has been taking place, that has taken place in the courts, on a daily basis, things that has been done, unconstitutional, and show you the ways that the judge has somewhat tried to help the state as much as he can to prosecute this case. And it's just been astonishing that, how can you be a referee and an attorney at the same time? The judge has been more of a prosecutor in this case than the prosecutors to me. All right? Now, we've been talking about the RICO for 2 years. Mm-hmm. But as you can see, the case was thrown out back then. So why are we still talking about a RICO? Why were we still trying to prosecute a RICO? As far as trying to make it stick when it was thrown out. You know what I'm saying? So it's just money. It's a lot of things that you all are going to, I'm going to show you all. It's a lot of things that I'm going to put before you all, and it's a lot of things that took place behind a lot of closed doors against these gentlemen, to where, the DA played a role in it, and other people who have their hands tied into this with the DA. So it's a lot of people playing a role in this case. It's just now it's coming out.
Nothing but the truth.
So you heard it, and you seen it right here on Nothing But the Truth.
That's right.
We're going to really get to some real critical points in this case as we go along the way and update everybody on the case. So I want you to stay tuned. I want everybody to keep their heads up, keep the prayers in for us, for all of these gentlemen, You know, and like I say, we're not just fighting for these gentlemen. We're fighting for anybody that's any of our loved ones and your loved one that's being held, you know, illegally incarcerated because of, you know, the games that the state wants to play with their lives. You know, we have people who have died in the jail. We have people who have been, you know, physically wounded in the jail. We have things that's going on in the jail that you can never imagine. And that's kind of ridiculous for a county jail. There's no way that our county jail should be being ran as if it was a prison. You know, we can't, you know, so, you know, we can't justify that. We can't justify the fact that some of the officers at the jail will tell you straight up with no hesitation if you inquire about the sheriff, and they will be freely to tell you the sheriff doesn't come here. You know what I'm saying? You know, and I witnessed that myself.
That's right.
I witnessed that myself. You know, and I had officers that actually said that the sheriff doesn't come to the jail. I had one officer told me, you know, hell, your guess just as good as mine. You know, that's not right. That's not appropriate. You know, we vote these people in. We vote these people in without checking them thoroughly. You know, and sometimes, you know, we be fooled by that. We be fooled by some of the things they say. We be fooled by some of the promises that they make to us. You know, but we understand that's politics. That's politics. You know, so at the end of the day, we as a people got to stand firm on the system because they represent us. They represent us. You know, it's sad to say, but these people represent us. You know, so on a good note and a bad note, you know, we have so many things that's a violation of our Constitution when it comes down to us going to, you know, being in these situations. We have a lot of things already against us day one. You know, we live every day with things against us as a black race. Our race is 95%. It's 95% stereotyped every day, regardless of what we do, whether it's something good or something bad. We are always behind the 8 ball. We are taxpayers too. We gotta let these people know we're taxpayers too. Some of us go to work every day. Some of us has to work every day. Some of us has to work to support our family. Some of us have to work to survive. You have to work to survive.
That's right.
So when your loved ones are being preyed upon because of status, because of their looks, because of how they carry themselves to a person that's on the outside looking in, you know, it's really, it's unfair. It's cruel. It's cruel. Because a man has dreads in his head doesn't make him a criminal. Because a man is black with tattoos or has tattoos on him doesn't make him a criminal. Mm-hmm. If you look in our judicial system right now, we got a lot of young people in our judicial system that's tatted up, got the dreads, female and male, you know, so how can you distinguish the two? How can you distinguish the two? You know, it's no such thing as fit the description. why they can wait you out. Because they're going home at 5 o'clock. Every day. Their life doesn't stop. Yours do. And they know that. They know that. They bank on it. If we can make him sit for however long we can mentally torture him, eventually he'll break. He'll break, take these bogus ass pleas. He'll break and take these bullshit charges, you know. So what win do you have? Once they get you behind that bar, those bars, you don't have no win. You have no win. If you have to wind up with a public defender, I'm not going to say all of them, because I have seen some real public defenders come to the rescue of their clients.
That's true.
They have put up good fights for their clients. So I applaud them. I applaud some of those public defenders that stand up for their clients, because as we can see now, ladies and gentlemen, they're really going against the grain. They're really going against the grain. That's why I have a lot of respect for Honorable Attorney Williams. She has a lot of respect from me. And I hope from you all, I hope from the world, because she is actually standing down to represent her client to the fullest. And she's taking a beat. I can guarantee you, from knowing the type of district attorney we have and the way she's running the district attorney office, I know she is taking a beating. And she's being punished. I really think that she's being punished for staying on this case. I really believe she's being punished for that. And what I mean by being punished is she can't handle the rest of her caseload. You know, but she's not being paid either, because that's how she makes her money, off of her caseload. So for her to be tied up in court, and for any other public defender that's on this case to be tied up in court for 2 years, that's a lot of punishment, man, you know, for trying to do the right thing, something that they have to swear in to do. You know, so for those public defenders that's on this case, hey man, y'all have my utmost respect. You have my utmost respect. You know, and that's why I want to continue to do what I'm doing, to give the people the praises who deserve it, because they are really fighting. They are really in a dog fight right now, and it's basically that they don't have any control over. They don't have any control over. So I would recommend this for any private practice attorneys or private practice firms. Give them a shot. Give them a shot, because as you can see, they stand up for what they represent. They actually stand up for what they represent. They deserve to be in a firm that can really, that really fights the law on a righteous note. On a righteous note. You know, so we gotta make a change. We gotta make a change. We gotta stand up. We gotta stand up. Our system, our law enforcement, our judicial system right now stinks. Stinks at all levels. It stinks. It really stinks. So we got to do something about it, people. We are the citizens of Atlanta. We are natives of Georgia. We have to do something about this corruption that's plaguing this city, this state. It's not just happening in Atlanta, people. It's not just happening in Atlanta.
Correct.
It's happening everywhere.
Right.
Everywhere, but we can only defend Georgia. We can only defend Georgia.
But as Dr. King said, injustice anywhere is a threat to justice everywhere. So if we're not going to stand up for our hometown, hey, you know.
We're going to take it. We're going to take the beating. We're going to take the bruises and the bumps when we don't have to. We don't have to. You know, so I fear for my family every day. I fear for my family every day. I fear for all of my loved ones every day because I just witnessed how they have us linked into the system to where a police officer can run one of our names in our whole family. Just anybody in our family that they can link to us comes up in the computer. So now I really know that my family is being targeted. My family is being targeted. I fear for my family every day. I fear for my life every day. I live in a fearful state of I don't know what might happen if I get pulled over and I say something wrong or do something wrong in a police eye, and it's probably somebody who actually has something against us. You know what I'm saying? Or, you know, one thing we can all be assured of, ladies and gentlemen, is 95% of the people over the world, the police has an alibi for pulling you over and showing probable cause just by coming up to your car saying, I smell marijuana. Really? Really? That's something you can say to anybody. That's something that our system over the world, any officer in the world can say that to you, whether it's true or not. Whether it's true or not. You know, so we gotta be real mindful of how we do things, how we carry ourselves, how we travel, how we ride, you know, how we look when we ride. You know, it's sad. It's sad. We gotta damn near paint our faces a different color to ride and to just be in the community that we were born and raised in. That's sad. It's a sad picture when you can't go back home. It's a sad picture when you can't go and be, you know, around the people who you've grown up with, people who you've eat, sleep, and drink with, people in your community that you have played sports with, people you have done a lot of things with. And it's always the persons with the names who gets the heat. And that's not right. That's not right, because I guarantee you, if we go to some of these other communities, they got far more people in the community with status. But they don't go through what we go through. We can't have a picnic. We can't have a function in the park, in the park that's in our area, in our zone, in our community, without it being deterred some kind of way by law enforcement. But I can go to Buckhead and I can go to Piedmont Park and sit out there and smoke marijuana if I want to. Crank up me a barbecue grill if I want to. Do damn near anything I want to do. But when I go to the community that we are from, it's limited. As soon as the word get around that we're trying to come together, next thing you see is police enforcement. They want to tow your cars. You know, they towing your car. They coming in telling you, you know, you got to leave the park because of this, that, and the other. Hey, man, you know, it's our community park. We're having a gathering in the community park. The city parks, sometimes we can go get a permit and still have some problems. Still have problems. We still be monitored. Monitored for what? Crime is everywhere. is something that we need to we got to make these people realize. Crime is everywhere. We just seen a young man get killed at Fogo Chao, whatever the name of it is.
Fogo de Chao.
Fogo de Chao.
Nigel Collins.
You know, why? Was he out of place? You know, did the officers just take upon themselves to say he's out of place? You know, I have seen videos where people have been in restaurants and something has taken place and the officer goes in there and just, you know, it just picks somebody to fit the description. You know, and instead of asking a question, they go in already assuming that this is the person. And then when something happens, they want to hide behind the shield. They hide behind the shield. But you see, we can see video of them doing improper procedures to people. And yet and still someone would say they had jurisdiction to do it. How we make that right? How can you make that right? How can you make wrong? How can you make somebody doing something wrong in your face right? It's not like we're not seeing it, people. We're seeing it. We're witnessing it. So hell, some of us record it. What good is a recording, people, when you're scared to give it to the right people? If you're going to record it, if you record something that's being done wrong to, you know, your loved one or someone else, and you recorded it, hey, man, why be afraid to give it to somebody who can push the buttons on it? Correct. Why? But yet and still, we'll still run around and say Black Lives Matter.
And that goes the same with what happened to Kendra Johnson in Valdosta. He was rolled up in a mat at school, murdered at school. And you mean to tell me nobody recorded it? Nobody saw it?
You know, so these are things, man, that's happening to our people everywhere, not just here. It's happening everywhere. You know what I'm saying? And we're going to start talking about it. We're going to start putting it out there. You know, hopefully it'll get someone's attention, you know, and try to, you know, make some changes in certain things. You know what I'm saying? Something sooner or later needs to go our way. And I mean the black community. You know, we have recreation centers in our community that our kids that's from the community can't even go to because they can't afford it. They can't afford it. So what's the purpose of putting it in the community? You know, it's a business. Is it a business or is it something for the community? Is it for the kids in the community? You know, everybody can't afford to do all this traveling to go to a certain recreation center, a certain park. Everybody can't afford to do that. You know, we got to start considering the people that's less fortunate. Correct. They need something to do too. They need somewhere to be able to go as well. So these are the things we got to start stressing in these community meetings. These are the things we got to start stressing at the committee meetings. We need to start going to these committee meetings. We need to start going to every meeting that they have, whether it's city, county, or state, and voicing our opinions, and standing up for our people, speaking on our communities and the things that are being done illegally to us. Unconstitutional. The Constitution has been, man, I'm talking about, you know, you can't even explain how much torture has been done to the Constitution throughout this case.
Butchered.
You know what I'm saying? The Constitution is shredded right now when it come down to this case. And not only this case, a lot of cases. This one is just bringing a lot of things to the forefront. You know, and it's all because somebody thought that they were smarter than the system. Somebody thought they were smarter than the system. Somebody thought that they had everybody in their pocket to where they can make something happen with nothing. With nothing. You know, now we have these guys sitting in jail. Judge been recused. We done went through three. We at the third judge now. You know, why? Why we can't find not one sane mind judge to handle a case, to sit in on a case, but yet and still, even though we looking for judges, why not get these guys that's able to get a bond? Absolutely. And let them go home?
Let them be innocent,
you know,
proven guilty, like the Constitution is supposed to be.
There you go. If we supposed to be innocent until proven guilty, why not give these guys a bond and let them go home and fight their case? Why not? You know, what can it hurt? It can free up a lot of beds, but what can it hurt?
State funding.
What can it hurt? It can't hurt. You know, because you're going to put a stipulation on them as if they just getting out, if they just did 20 years out in prison.
Anyway.
You know, you're going to make money off of them. You're going to make sure you can get a dime off of them. Definitely going to do that. But why not get them a preset bond? You gave it to 19 other people. Why not give them a signature bond? You gave it to 19 other people. Because I would have to see it on paper. I would have to actually see it on paper that any one of the people in the Trump RICO paid some money to bond out. I would have to see that on paper. I would have to see that. That's the only way I believe it. So what's the difference? What's the difference? You know, if we go call a spade, let's call a spade. We got to do the right thing. We got to make sure our system start doing the right thing toward our loved ones. Because, like I say, and I'm always saying, it could be your loved one. It could be yours next. It could be you could be a family that's out here living in fear because the system has targeted your family for some other reason. For some other reason. So, you know, once again, you heard it here, and you heard it live, and you heard it willingly. On Nothing But the Truth.
Nothing but the truth.
So, you got anything else?
Same thing we've been saying. Don't let it happen to you before it matters to you.
That's it. Let's start stepping on it. Let's start stepping on it before it hit us. Let's do that. We got to do that. We got to put together some functions for us to come together as a community again and let these people know that we love each other. Let these people know that we do care about each other, regardless. Because we do. That's what we come from. That's how we were raised.
Now let's change this narrative that the media likes to portray. Like he said, that black people or black men don't love each other, don't get along, black on black crimes. There's more love than hate. And as he stated, we just need to start finding the outlets that show the love versus constantly feeding the media the hate.
So we're going to end today with, you heard it right here, NDO Radio. Big Jeff signing off
Shanita signing off.
on Nothing But the Truth. Peace out.
Yeah.